Hello, fellow business law classmates and Professor Franstead. My name is Samuel Nichols, and today I'm going to be talking about family leave under the Family Medical Leave Act, or more commonly known as FMLA. So, some background on the Family Medical Leave Act, or FMLA, is the purpose was to balance the demands of the workplace with the needs of families. This law was signed by President Clinton in 1993 after being enacted by Congress. This was a very big part of President Bill Clinton's first term. It was something he really wanted to get done. It was a very successful thing in his presidency because at the time employees weren't really guaranteed there's nothing in law stating that the employee would still be able to keep their job after having to take a family medical leave. So now let's talk about what is family leave in the Family Medical Leave Act. The Family Medical Leave Act only applies to immediate families such as a parent, spouse, or child, and can be used for an employee's own serious health condition, the serious health condition of a family member, such as above, only immediate family, a parent, spouse, or a child, or also upon the arrival of a new child, whether that be through childbirth, adoption, or placement from foster care. To be eligible for an unpaid job protected leave, the employee must have been employed with the current employer for at least 12 months and worked at least 1,250 hours from the same current employer. So a little more about FMLA, kind of who they are and where they come from and who's in charge of them. A counterpart of FMLA is the Wage and Hour Division in the Department of Labor. So if you ever wanted to go to the Wage and Hour Division, there's district offices in each state. In Michigan, we have one in Grand Rapids as well as one in Detroit. So who, I guess, the governing body of who is in charge of FMLA would be the Wage and Hour Division. Now, the Wage and Hour Division is underneath the Department of Labor, so if it kind of goes down, it goes from Department of Labor to Wage of Hour Division, and then Wage and Hour Division is in charge of enforcing FMLA. If an employee feels their FMLA rights have been violated, they can file a complaint with the Department of Labor. So you don't go directly to the Wage and Hour Division, you first file a complaint with the Department of Labor. Or you can file a lawsuit, but the Department of Labor recommends you file a complaint first. After you file your complaint, the Wage and Hour Division will then investigate the complaint. That's why they say hold off on filing a lawsuit before the Wage and Hour Division comes and investigates. So, what relevant cases that have been recently that have applied to FMLA and help make a decision about the law? I looked up Escriba versus Poultry Farms. This happened not too long ago, November 7th, 2013, so about 3 years ago. There was an employee who had taken FMLA many times already that year, and the employee did not want these upcoming absences to be counted as FMLA, but instead use vacation time. But she had stated she was going to go take care of her sick father in Guatemala. But she stated to her manager she wanted to take vacation. So she went on vacation and did not return until well after her return date. She was subsequently terminated for this, but she filed a complaint stating her leave was clearly for FMLA reasons. Now, the court sided with the company because she did not go directly to HR and request FMLA as she had done the several times before, which I stated. She said she's taken family medical leave several times before, and every other time she had gone to HR and said, I want FMLA. But instead this time, she went to her manager and told him she wanted vacation to go take care of her father. So whether she was trying to play it smart or play a trick on them, we really don't know. But the court had sided with the company, stating she did not really want to use FMLA because she did not go to her the HR, and she did not intend to use FMLA. So since this ruling, the court stated employees could refuse to take FMLA even if their leave would be protected. So in a way, it would have protected her if she could go take vacation. This also prevents employees from so-called doubling down and using vacation as well as using FMLA at the same time. You can only do one or the other, the court decided after this. So what this means for us is just make sure that employees go report to HR when they would like FMLA. So some suggestions, like I just said, notify HR that you would like an FMLA leave. Do not notify your supervisor or manager. Go directly to the HR office and tell them you would like FMLA to clear up any sort of confusion that may occur with your manager, and the HR rep will know exactly what to do for you. Know who and what applies to FMLA. So, like I talked about in the beginning, only immediate family, parent, spouse, or child, and what applies. So, your own illness, a serious illness of one of the immediate family members, or upon the arrival of a new child. Know how to file a complaint through the Department of Labor if you feel your FMLA rights have been violated, and then an investigation will incur from the Wage and Hour Division of the DOL. And make sure, know if you qualify for FMLA. So minimum employment, you need 12 months of employment, as well as 1,250 hours of working with that employer. And know that employees only get 12 weeks of unpaid leave a year. So once you reach your 12 weeks in a year, you will not get any more, and your job will no longer be protected. So that's just some tips for employees of any organization that they should know. Here's just some references. Thank you for watching today. I hope you guys learned a little bit more about family leave underneath the Family Medical Leave Act. Thank you very much.